Hey guys, welcome back to another episode of Hauscast. Really appreciate you tuning in. Jeremy here. A little bit different setting today. We're doing it online, just mixing it up. And I'm hosting independently today, so we're going to see how I manage, but we're going to have a lot of fun. We got a great guest. We've got Shannon Durno with us here today. Shannon goes back with my dad. They've worked together in the past and history even going beyond that. So thanks for coming on, Shannon. Really appreciate it.
Hi, Jeremy. Thanks for having me on, and thanks again for the opportunity. And hi to all the listeners of the podcast. I am a real estate lawyer primarily. I am the owner of Durno and Shea, and we do a high volume of real estate. So we've seen lots of different types of deals, and yeah, the history goes back a long time.
Yeah, for sure. It's I know for myself, when doing real estate, the lawyer aspect of it can be a little bit intimidating for people, and even for myself. And just if you want to give a brief, kind of how do you kind of play into the real estate aspect of the deal? How does the lawyer come in? When does it come in?
Yeah, of course. Usually we get involved once there is an agreement of purchase and sale signed. Some cases it might be conditional, some cases it might be firm, but that's when we step in. We start to review the offers, we speak with clients, kind of go from there with speaking with the other side, the seller or the purchaser's lawyer, depending, and the banks.
Yeah, so pretty straightforward. And do you always need a lawyer for a transaction?
Yes. In Ontario, both the buyer and seller require their own independent lawyer. One lawyer cannot act for both parties.
Okay, yeah. So we'd have some conflict of interest, right? So trying to keep things kosher.
Exactly. So someone representing each party's interests.
Yeah. So it's a bit of a meticulous process going through, right? Is there something that you look for specifically, or is there anything that would kind of give you red flags when looking through a agreement of purchase and sale?
Yeah. So generally, like if we're reviewing an offer, first, I would say that in a hot market, most of the agreements that we receive are firm and binding. So at that point, we can't make changes to them. But maybe in this cooling market, we'll tend to see some offers that have conditions, maybe some financing or home inspection conditions. And we're looking at them to see first, very simply, like, are the details right? Are the owners listed as they're supposed to be? Is the legal description right? Beyond that, looking at like the dimensions of the property, if it's a house, to make sure purchaser is getting what was contracted for in the agreement of purchase and sale. Yeah.
Okay, so is there anything that would like be cause for concern for you guys when you're going through it? Like if you saw that like if they had a survey and they said the lot dimensions and it doesn't match up, would there be repercussions for something like that?
Yeah, I mean, so if you're looking at it, whether it's through the search or through a survey, and you discover that the dimensions are incorrect, of course, in the offer it says more or less. So if it's close, it is what it is. There's also the argument that a buyer is getting exactly what they saw if they've seen the property. So there might not be a lot of recourse, but regardless, you still want to point it out to the buyer and see if there are actions and if there is any wiggle room for an abatement or something like that.
Okay, so it'd be more so just a starting point for a conversation to see how they can resolve it if need be, if it is something more minor, right?
Correct, yeah.
And if we do get towards like the major side of some conflicts, how do you come into that? Like with the market shifting, I know some buyers had to pull out of deals once they're firm. What does that recourse kind of look like?
So yeah, if it comes about where a buyer is looking to pull out, I mean, first off, you're not going to see many deals completely fall apart. In a lot of cases, a buyer is going to ask for an extension, usually due to financing. And if this is the case, yeah, we'll go through what a seller would ask for. But if it comes to a point where an extension isn't requested or it can't be agreed upon between the buyer and seller, this is where a seller then has to show their ability to close, that they're ready, willing, and able to close the deal. They would sign all the documents with us. We'd get everything to the purchaser's lawyer, including either keys or lockbox code, depending. and then write to them and say that the purchasing client is in default. And basically the seller will relist the property to mitigate their damages. And then they'll also keep their options open to pursue further litigation if they're out of pocket.
Yeah, down the road, because I know a lot of people talk about like if a deal falls through, you get the deposit automatically from those buyers. Is that the case?
No, and this is a misconception among buyers and sellers alike. If a deal does fall apart for either party, if they can't close, the deposit remains in trust with, generally they're with the listing brokerage, so it will remain in trust with them until either you get a mutual release, which would mean that both buyer and seller sign off to say that we're releasing each other of liability. And we've decided to split the deposit as such. For a seller, probably not a great option until you know that you've resold the property and closed it successfully, and you can account for any difference between what you originally sold for it and any carrying costs. Outside of that, the deposit will be released through an agreement between the buyer or seller or a court order.
Okay, so they could go down the route of a court order. Would that mean like suing the buyers for the difference if they were able to sell with someone else?
Yes, exactly. So if you sold it for $100,000 less, you could then sue the original buyer for the $100,000 plus any other costs that are involved. So like insurance, utilities, property taxes, etc. Yeah, but I mean, of course, no one wants it to end up in litigation because it's going to be years and time consuming and costly and stressful. So in most cases, people will try to negotiate an extension. But if it does go down that route, there are legal avenues through civil lawsuit for the seller or the buyer if it was the seller who defaulted.
Yeah, there's options in place because, like you said, it can be a really stressful process for people to be going through. So it's good to have those options available to you if need be, right?
Exactly.
And then for another part of going through everything, the title search. I know for us, we usually give 2 weeks for a title search. Is that enough time? And kind of what goes into the title search? Because it feels a little airy for people, really, I bet.
Fair enough. Yes. So the 2 weeks, generally, it is fine. However, you come across issues. If they're minor issues, you will likely be able to resolve it within the 2 weeks. If they're complex, it won't be enough time. So a minor issue could be something such as like an old mortgage on title. If this old mortgage on title, if the financial institution still exists, likely we're going to be able to, with some persistence, get that discharge and get the discharge statement so that we can take care of it. Where you run into trouble is if it was an institution that no longer exists, or if it was a private lender that no one knows where they are or if they've passed, then you're going to be in a situation where you might need a court order, which is going to take, again, probably months and cost to the seller. But this isn't something that comes up a lot. It's more of a rarity. Let's say like an easy fix on a title search might be like an expired easement, like for utilities or a builder to enter.
Property.
On those, you can just usually, in most cases, write to like submit a PIN correction to the land registry, and they might just delete it. But regardless, this isn't something that's a large issue because it's expired anyhow. But yeah, if you've got the complex issues like an incorrect legal description, you might not be able to resolve it in time for closing, but there are solutions. Like you could do a holdback where the seller's lawyer, the purchaser's lawyer holds back some of the seller's proceeds until the issue can be rectified, and also reach out to title insurance to see what kind of protection coverage they're going to give to the buyer.
Okay, yeah, so that it really is on the seller to kind of mitigate the situation, and the buyer does have protection in case something happens.
Yeah, and it's the job of the purchaser's lawyer to make sure that their client is getting good ownership, good title to the property, and it's not subject to any of these encumbrances.
I was just asking, is there ever a time where a title search isn't able to be resolved? Like if there was something that couldn't be be figured out with a holdback or something like that. Would those situations ever arise?
Yeah, they certainly could. I would say it's very rare that you've got a
Hmm.
situation that can't be resolved. But if there is something that goes to the root of title that can't be resolved satisfactory to the purchaser, or title insurance won't cover them or their lender, then you might have a situation where the deal needs to be terminated. But again, this is not something that you're going to see often.
Does the buyer have any recourse against the seller if the deal falls through because the seller didn't have a clear title or something? Does the buyer, I don't want to put it so bluntly, but like get something from the seller or anything like that because they didn't get the deal, or is it just kind of too bad?
It's kind of tough whether there is recourse for the buyer. There
Hmm.
might be legal remedies depending on what it is and if it's a specific type of property. Um, but otherwise, I mean, it might just be a situation where the buyer wants to walk away from it and just wants their deposit back and to move on and to buy something that doesn't have these issues.
Yeah, better to just save the headache than try to make it work, right? Force it through.
In some cases, yeah.
That makes sense. And then kind of transitioning away from the freehold side to condos. I know a lot of people with condos, they deal with status certificates and it can be a little bit daunting for people.
Yeah. So, yeah, I mean, in a hot market, you're going to see that deals are not conditional on status certificate.
Okay.
In this cooling market, I think potentially you'll see, I'm personally seeing more deals that are conditional on status certificates. But regardless, usually the status is reviewed. And what we're looking for, first off, is does what's in the offer, does it match what's in the status? So for instance, if the offer said the buyer is going to get a parking space and a locker, does that exist in the status? And if not, we
Hmm.
obviously have a problem. Um, Also, what are the maintenance fees? Are they same or roughly the same as what was said in the offer? And does this include utilities? So those are kind of like the basics, but then we're looking to the status to see whether they have a good reserve fund. Are there any lawsuits against the condo corp? Is
Hmm.
there special assessments or a track record of special assessments? Like, are the maintenance fees going to increase a lot over the next few years or several years? And the way that we look at that is there's something called a reserve fund study.
Hmm.
And the reserve fund study is supposed to be done every 3 years by the condo corp. And it's done by an outside body, like an architect, engineer, looking at the when the common elements, when they're going to need repairs and replacements and what are the costs of these. So what is going to be needed in the reserve fund. So basically it's indicating like what kind of increases they're going to need from the owners on a monthly basis.
Yeah, it gives you an idea of kind of the future of the building and what direction it might be going, what kind of things might need to be addressed, right?
Yeah, and if it's a poor reserve fund, it's something that you want to point out to your purchaser because this could mean monthly increases to their maintenance fees more than they're expecting or more than they can budget for. It could
Hmm.
also mean a special assessment, which is like a one time or a few time levy, being like out of nowhere, they've got to pay thousands of dollars to do something. So this is something, if we can see it in the status, obviously we'd like to bring it to the purchaser's attention.
Okay, perfect. That makes sense. And just touching back on special assessments. So just to clarify what those are for people, it's something that would be a one-off against the condo to fix something, or
Yeah, usually. So if there's something maybe that came up unexpectedly, or the condo hasn't budgeted properly, they'll say, okay, we're replacing the elevators, let's call it, and it's
Mhm.
going to be this amount. So divided over your percentage, you owe X amount, and they might spread it over a few months or 6 months or a year, but it's still going to be a lot of extra money that an owner might not be expecting.
Yeah. So I guess the thing to understand with a special assessment versus the review we're talking about, special assessments might come out of the blue.
They could, but the hope is that a well-run condo and with a good reserve funds is that this won't happen and that the costs will be very expected to the owner and no major increases.
Yeah. So basically, if you're seeing not many special assessments, it means that you've got a responsible condo corp that is making sure that things are being addressed when they need to be.
Yes, and hopefully, but I mean, I guess you can look at it the same as a house. Like things happen, like
Yeah,
your
things come
furnace,
up, right?
your furnace could break and all of a sudden you're stuck with a few $1,000s and maybe you weren't budgeting for it. But the hope is with the condo fees that it's incremental and nothing unexpected.
Yeah, they're able to kind of mitigate it a little bit better instead of a lump sum, right? So that they can make it a little easier on residents.
Yes.
And another thing you mentioned looking for would be lawsuits. I know that would probably scare a lot of people, but kind of going into the details, what could lawsuits entail with a condo corp?
So we see a lot. I think the most frequent one that I would see is like personal injury or slip and fall, wherein someone has allegedly been injured on the property. So now they're suing the condo corp. In most cases, the condo corp is going to have their insurer defend this. So it might not be a major cost to the unit owners, but I mean, of course, any of these lawsuits, they're going to increase your insurance costs, the money that they pay to lawyers. So it can all add up. But I mean, I don't think that a slip and fall or person injury specifically goes to the management of the building.
Yeah. And that wouldn't, I guess, a lawsuit wouldn't necessarily, if you see one, it wouldn't be a red flag to stop you from wanting to pursue a condo necessarily, because things might happen, right?
Yeah. And I mean, looking at the picture in a whole, if it's like a one-off, then yeah, it might not be a red flag. It might just be make sure your buyer is aware. And these are the possibilities. I mean, if you're seeing lawsuits for like deficiencies in the building, I think that is more of a red flag because these could be ongoing costs no matter who's at fault.
Yeah.
So that might be more of a red flag than, say, a personal injury claim.
And then with the status certificate, so it's there's a lot that goes into it. What's the best way for you guys to convey it to the clients, to myself even, because it's a lot to go through. What's the process for you guys?
Well, I try to summarize it to clients. I mean, there's a lot in there, as you said. You've got like the budget, the financial statements, reserve fund study, the rules. I do like to point out the rules to clients, though, because for a lot of people who have pets, pets are part of their family. So in those cases, I want to say, okay, if you have a dog, maybe they don't allow dogs, or maybe they say, okay, there's a limit. So I like to make sure clients are aware of that sort of thing and take a look at those. But also I go through it. I'll either send an email on like a summary of the findings or give the client a call or both, depending on, and just kind of point out the good, maybe potentially like a red flag so that they're aware of what they're getting into. Try to lay it out for them as easy as possible.
Yeah. And for yourself, would you be advising a client about to go in on a condo, or would you tell them, no, don't do this because there's too many red flags? Like, what would you find yourself giving that kind of advice as well?
Yeah, I mean, in most cases, I feel like statuses are generally on the better side, but I do come across statuses that, yeah, you're going to see a low reserve fund, some like major increases in maintenance fees or special assessments. And yeah, my advice at that point would be, this is probably not the best purchase, and here's why. But ultimately, if you set it out for them and they're aware that, yeah, this could increase, this is the potential outcome, and they still want to go through with it, that's their choice. It's just for us to make sure that they're aware of what the cost could be or what the red flags are.
Yeah. It's our job to give advice. It's their job to give us the instructions, right?
Exactly. Yeah. You got it.
Yeah, no, good stuff. Really appreciate that. That really summarizes a lot of the big topic areas for how a lawyer plays into the real estate transaction. I'm not sure if there's anything else that you want to add about kind of the process that you go into.
Yeah, so we get involved once the offer is once there's an offer, usually. I mean, we do have clients who reach out before with general questions, and always happy to answer those. Just maybe about the process or what happens. But yeah, then once we get an offer, we get in touch with our client. We, again, depending on where they are, like if they're first-time buyers, they're going to have a lot more questions, and happy to do a phone call or video call or meet in person. Probably less popular, but and go through, just what they need to do and what they should expect and kind of like the timelines. But yeah, with more like buyers who have done this a few times, they probably have less questions. But from there, we're getting involved. We're reaching out to the buyer or seller's lawyer accordingly. If we're acting on the buy side, we're starting to do title searches and tax lookups and all of our due diligence. A lot goes on in the background that people are probably not aware of. Just communications, even just with the other side and the banks. And then of course meeting with people.
Yeah, it's a lot that goes into the process, but it's for you to make sure that the people feel they got a straight head, right, with all those questions. So
exactly, and always, we're always happy to answer it throughout the process, because I think sometimes at the beginning people don't, especially first-time buyers, don't even really know what to ask, and then as it goes through, like they might have different questions.
Yeah, different things pop up, right? So really appreciate you answering all my questions today, Shannon. It's been great chatting.
Yeah, great to chat with you too, Jeremy. Thanks for having me on. And again, if anyone has any real estate questions, feel free to reach out to me. I'm sure my information is in the podcast.
Yeah, we'll be linking that out. So thanks again, Shannon, and thank you for tuning in. It was a great episode, and we'll be sure to get your information out there to everyone who needs it. And if you got any other questions or concerns about real estate, you know where to find us. We're here to help out. So take care, guys, and have a good one.
Bye, guys. Thank you.